Dear fellow citizen, I welcome you in another part of procedure for amendment in our constitution, in the series of our constitution. Article 31C, which was introduced by section 3 of the 25th Amendment Act, provided a that if any law seeks to implement the directive principle contained in Article 39 BC, that is regarding socialistic control and distribution of the material resources of the country, such law shall not be void on the ground of contravention of Article 14 or 19. B. It further provided that if anybody challenges the constitutionality of any such law, the court would be precluded from entering into the preliminary question, namely whether such law is in fact a law giving effect to Article 39B or C, if on the face of the Act there was a declaration of the legislature that it is for giving effect to such directive policy. In other words, by adding a declaration to an Act, the legislature was empowered by the 25th Constitution Amendment Act to deprive the court of their power to determine the validity of the act on the ground that it is contravened some provisions of the Constitution. The majority held that Article 368 did not confer any such power to take away any judicial review in the name of amending the Constitution. The foregoing view of the majority in Keshavanand's case as to basic features are debatable inasmuch as there is no express limitation upon the amending power conferred by Article 368(1). If it is supposed that there are some implied limitations, it is difficult to appreciate how the court, after holding that the fundamental rights did not constitute such inviolable part of the Constitution, could come to the conclusion that judicial review, which is an adjunct of fundamental rights, could be so considered. It would therefore be no wonder if another full bench of Supreme Court comes to overturn this view of Keshavanand's case on the grounds that Article 368(1) as it stands amended in 1970 and 71 makes it clear that not only the procedure but also the power to amend the Constitution is conferred by Article 368 itself and cannot be derived from somewhere else, such as Article 224.5. Hence, Article 245. Hence, the limitation, if any, upon the amending power must be found from Article 368 itself, and not from any theory of implied limitation. That the word repeal in Article 368(1) also makes it clear that amendment under Article 368 includes a repeal of any of its provision, including any supposed basic or essential provision. That the Constitution of India makes no distinction between amendment and total revision, and as do some other constitutions such as Swiss. Hence, there is no bar to change the whole constitution in exercise of the amending power, who is described as the constituent power, Article 368(1), and that accordingly it would not be necessary to convene a constituent assembly to revise the constitution in toto. The Indira government sought to arrest these implications of Keshavanand's and cut the fetters sought to be imposed on the sovereignty of Parliament as a constituent body by inserting two clauses 4 to 5 in Article 368 by the 42nd Amendment Act 1976. Clause 5 declares that there shall be no limitation on the constituent power of Parliament to amend the provisions of this Constitution, and that At any rate, the validity of no Constitution Amendment Act shall be called in question in any court on any ground. The foregoing attempt to preclude judicial review of Constitution amending acts has, however, been nullified by the Supreme Court by striking down Clause 4(5) as inserted in Article 368 by the 42nd Amendment Act by its decision in the Minerva Mills case, on the ground that judicial review is a basic feature of the Indian constitutional system which cannot be taken away even by amending the Constitution. So far, the decision in Kesvanandaj has been followed in subsequent cases by the Supreme Court. As a result, Article 368 as to interpreted by the highest court would lead to the following propositions. Any part of the Constitution may be amended after complying with the procedure laid down in Article 368. No referendum or reference to Constituent Assembly would be required to amend any provision of the Constitution, but no provision of the Constitution or any part thereof can be amended if it takes away or destroys any of the basic features of the Constitution. Thus, apart from the procedural limitation expressly laid down in Article 368, substantive limitation founded by the doctrine of basic features has been introduced into our Constitution by judicial innovation. The Supreme Court has refused to foreclose its list of basic structure features from the various decisions. So far, the following list may be drawn up: supremacy of the Constitution, rule of law, the principle of separation of powers, the objectives specified in the preamble to the Constitution, judicial review, Article 32 and 226, federalism, secularism, the sovereign democratic republican structure, freedom and dignity of the individual, unity and integrity of the nation, the principle of equality, not every features of equality, but the quintessence of equal justice, the essence of the other fundamental rights in Part 3, the concept of social and economic justice to build a welfare state, Part 4 in toto, the balance between fundamental rights and directive principles, the parliamentary system of government, the principle of free and fair elections, limitations upon amending power conferred by Article 368, independence of judiciary, effective access to justice, power of the Supreme Court under Article 32, 136, 141 and 142, legislation seeking to nullify the awards made in exercise of the judicial power of the state by arbitration tribunal constituted under an act since its commencement on January 26, 1950, Constitution of India has been amended 83 times till December 2000 by passing acts of parliament in the manner prescribed by Article 368. See Table 4 post. Since all these amendments acts have been mentioned with full particulars in Table 4 post, it is needless to reproduce them in the present chapter. Nevertheless, the 42nd and 43rd and the 44th Amendment must be given a fuller treatment in view of its serious repercussions in the political as well as the legal world. All previous amendments paled into insignificance after the passing of the 42nd Amendment Act 1976, which alone would illustrate how momentous is the amending power under the Indian Constitution and how easy it is to change extensive and vital provisions of Constitution without any elaborate formalities when the ruling party has a comfortable majority in the two houses of Parliament. The 42nd Amendment Act was practically a revision of the Constitution for following reasons. In extent, it introduced changes in the preamble, as many as 53 articles, as well as the 7th schedule. As to substantive changes, it sought to change the vital principle underlying the 1949 Constitution. Judicial review of ordinary laws. It made for the first time a distinction between union and state laws for the purpose of challenging their constitutionality on the ground of contravention of any provision of the Constitution, and provided broadly that a high court could not pronounce invalid any central law, including subordinate legislation under such law, on the ground of unconstitutionality, that the Supreme Court could not in its jurisdiction under Article 32 pronounce a state law as unconstitutional unless the central law had also been challenged in such proceeding. If any law was made to implement any of the directives included in Part 4, Article 31C, or in exercise of the new power under Article 31D to ban antisocial activities or associations, the validity of such law could not be challenged on the ground of contravention of Article 14, 1931. Above all, an artificial majority of judges was required both in the Supreme Court and High Court in order to pronounce a law to be unconstitutional and invalid. Judicial review of Constitution Amendment Act. By amending Article 368, it was provided that a law which is described as a Constitution Amendment Act would be completely immune from challenge in a court of law, whether on a procedural or substantive ground. Thus, even if such a bill had not been passed in conformity with the procedure laid down in Article 368 itself, nobody would be entitled to challenge it in any court on that ground, a position which is juristically absurd. Fundamental duties. For the first time, a chapter on fundamental duties, Article 51A, was introduced in order to counteract the sweep of fundamental rights. Even though no sanction has been appended to these duties, it is obvious that if a court takes these duties into consideration along with fundamental rights, the scope of the free play of the rights would to that extent be narrowed down. Fundamental rights devalued. By expanding the scope of Article 31C, it was provided that if any law seeks to implement any of the directive principles included in Part 4, such law would be altogether immune from the judicial review on the ground of contravention of fundamental rights. This is exactly the reverse of what was provided in the 1949 Constitution. The load on fundamental rights, in short, became ruthlessly heavy after the cumulative burden of Article 31A, 31B, 31C, 31D, and 51A. When the Janata Party came to power towards the end of March 1977, they sought to take early steps to fulfill their election pledge to undo the extensive mischief which had been done to the Constitution by the 42nd Amendment Act as outlined above. But owing to the fact that Janata had no majority, not to speak of two-thirds majority in Rajya Sabha, which was required to pass a constitution amending bill under Article 368. Their attempts in this behalf were checkered and not only partially successful. The first step was abortive, namely that the 43rd Amendment Bill, which was introduced in the Lok Sabha in April 1977, had to be left over till the next session, hoping to gain some more seats in Rajya Sabha at the periodical election to be held into that house. In the meantime, eventually the 43rd Amendment Act 1977 was passed with the aid of the votes of Congress. The attitude of that party, however, changed when the next bill, which the 45th, was taken to the Rajya Sabha in 1978, as a result of which this bill was enacted only in a truncated shape as the 44th Amendment Act 1978. The changes made by the 43rd and the 44th Amendment Act were summarized in Table 4 post briefly speaking. This is all about today's procedure for amendment in the series of Constitution. We shall discuss about the important features of 43rd and 44th Amendment Acts summarized in Table 4 on tomorrow. Thanks, regards.